All right. Good morning, everybody. My name is Mark Volashin. I am the Deputy Secretary of State for Elections, for the record, and I will call this adoption hearing to order at 9:03 a.m. Before we start, I do want to make a quick announcement. Here in Carson City, the state government offices have been closed by the governor, but we are still going to hold this adoption hearing. So there will be one change in venue. If you are interested in coming to see this proceeding in person, instead of going to the legislative building, I simply ask that you walk about 100 meters north to the Capitol building, where I am currently standing. So if you come to the Capitol building, the Capitol Police will be able to direct you to our office, and you'll be able to attend in person here in the Capitol building. So again, while the legislative building is closed in the north, you can see the legislative building down south in Las Vegas is still open. We still have an option available on Zoom. If somebody is interested in participating, you can always also call in. I'll provide that number now. The number is 1-888-475-4499, and then provide the meeting ID number, which is 839-7596-4928. Again, that's the phone number, 1-888-475-4499, and then provide the meeting ID number of 839-7596-4928. When prompted for a participant ID, press pound and then *9 to take your place in the queue. Again, though, because of the change in physical venue here in Carson City, what I'm going to do is I see the clock says 9:05 right now. We're going to wait about 15 to 20 minutes to let everyone that has gone to the legislative building work their way to the Capitol so they can attend in person as well. And then we will continue with this regulatory adoption hearing. So again, I have 9:05 now. I will pause. We'll go outside to see if anybody is coming over, and we'll give 15 to 20 minutes to make sure everyone is settled. So thank you, and we'll be back at about 9:20. Okay, good morning, everybody. Again, we've waited about 15, 20 minutes now to see if anybody, again, let me back up. My name is Mark Volashin. I'm the Deputy Secretary of State for Elections, for the record. Because of the weather, again, just to clarify for everyone, because of the weather and the closure of state buildings in Carson City, and up north, there's a number of counties where state offices are closed. We have moved the in-person location so that if somebody is interested in attending this regulatory adoption hearing in person, instead of going to the legislative building, which is now closed, again, we simply ask that you walk about 100 meters to the north to the Capitol building itself. And if you come in the front door of the Capitol building, take a right, you'll be able to walk over to the Secretary of State's office, and then we'll bring you in so that you can take part in this regulatory adoption hearing. We waited about 15, 20 minutes, like I said, to see if anybody else showed up. And again, I'll make that announcement kind of periodically in case questions come up. Okay. If you are interested in participating, though, and you would like to call in, you're still able to do that. You can always call 1-888-475-4499, and then provide the meeting ID number, which is 839-7596-4928. Again, the phone number is 1-888-475-4499, and then a meeting ID number of 839-7596-4928. When prompted for a participant ID, press the pound button and then press *9 to take your place in the queue. Again, this is the adoption hearing for the Secretary of State Elections Division's proposed regulations with the following LCB file numbers: R001-26P, R002-26P, R003-26P, and R103-25P. We're going to start this morning with public comment on matters not on the agenda. Comments will be limited to 2 minutes per person. We'll start again in Carson City, then go to Las Vegas, and then go to the phones. There's nobody here in Carson City, so we'll go to Las Vegas. Don't see anyone coming to the table. Broadcasting, could you please check phones?
Thank you, Chair. If you would like to provide public comment, please press *9 now to take your place in the queue.
Good morning. My name is Kayla Maese, Kaylah. Last name is Maese. I'm the policy manager with the ACLU of Nevada, and we did submit a proposed conceptual amendment, and we just wanted to say thank you to you and your team, Mark. Thank you so much. Have a great day.
Chair, you have no more callers wishing to provide comment at this time.
Excellent. Thank you, Broadcasting. In that case, we will close public comment on matters not on the agenda, and we will move on to the regulations. Agenda item 3. It is noted for the record that the regulations will be addressed one at a time in numerical order. Public comment will be taken in the same order, and public comment on a particular regulation will be closed before moving on to the next regulation. Before public comment is opened on each regulation, I will read into the record a summary of the proposed changes. I will also include a list of the suggested changes that we will be incorporating into the final text prior to the meeting of the Legislative Commission on February 26th at 1 p.m. Before we begin, I want to clarify a few things. Our discussion today during this adoption hearing will be focused on the proposed regulations listed in the agenda. We should not discuss changing statutes, which are, of course, created by the legislature. This regulatory process will not alter any existing laws. Regulations, after all, cannot make something illegal that is otherwise legal, nor make something legal that is otherwise illegal. These regulations in this regulatory review are intended to update our regulations based on experiences learned from the previous election cycle and clerk and registrar input with the expressed intent of increasing security, transparency, and accessibility. This adoption hearing is not the end of the regulatory process. Following the completion of this adoption hearing today, the next step will be to go to the Legislative Commission, which will be occurring next week on February 26th, which is Thursday at 1 p.m. Further, we are here today because of two specific statutes, NRS 293.124 and NRS 293.247. NRS 293.124 establishes the Secretary of State as the Chief Officer of Elections. It states, in part, the Secretary of State shall serve as the Chief Officer of Elections for the state. As Chief Officer, the Secretary of State is responsible for the execution and enforcement of the provisions of Title 24 of NRS and all other provisions of state and federal law relating to the elections in the state. The Secretary of State shall adopt regulations as are necessary to carry out provisions of this section. NRS 293.247 states, in part, the Secretary of State shall adopt regulations not inconsistent with the election laws of the state for the conduct of primary, presidential preference primary, general, special, and district elections in all cities and counties. There's a lot more to it, but those provisions have brought us together today. If there are general questions about elections procedures, I'll be able to discuss them as long as they relate to the proposed regulations. If there are questions that extend beyond the regulations on the agenda, I would be more than happy to set up a separate meeting at another time. To do so, please contact me at ndelect@sos.nv.gov. As of this morning, the Secretary of State has received written public comment from multiple organizations and individuals. The written public comment received by the Secretary of State's office is hereby submitted into the record. A workshop was held to solicit public comment on January 16th of 2026. Since then, the Secretary of State has continued to receive written feedback relating to the proposed regulations that we will discuss today. I will address some, but not every one of the proposed suggestions and comments received. Some of the suggestions have been incorporated into these proposed regulations. In those cases, the amended text will be described, but the final version of the text will be available prior to the meeting of the Legislative Commission next week on February 26th at 1 p.m. Other suggestions will require further research and analysis over the coming months, but may be considered for separate regulations following the 2026 election cycle. Some suggestions conflicted with existing statute or exceeded the scope of these regulations and were not considered. Finally, the Secretary of State had a number of requirements to weigh in the consideration of provided public comments, specifically related to increasing security, transparency, and accessibility. While many of these proposed regulations create additional requirements for the clerks, registrars, and Secretary of State staff, it's important to recognize that the work required by our state and county election officials has increased over the last few years. Altering these proposed regulations to make them more stringent or to greatly increase requirements could make them impossible to accomplish. Therefore, in many cases, we are moving forward with measured, reasonable improvements, but with an eye on future modifications that will be based on lessons learned during the upcoming election cycle. A few administrative notes. I'll be taking notes while you're providing comments. If you see me looking down, it's because I'm typing. Once I get to the public comment, I will first take public comment here in Carson City, then in Las Vegas, and finally on the phones. To be clear, this meeting is a discussion. If you ask a question, as long as it is related to the agenda item, I will be able to answer it. Once we are complete here today, my team and I will discuss and analyze final suggestions, bringing them to the clerks for input if necessary before ultimately making any final recommendations to the Secretary before the meeting of the Legislative Commission. Finally, I understand that discussions about elections can get intense, and I'm excited about talking with you today, but I must ask that each of you treat each other with dignity and respect. Your fellow Americans in the room and listening in today may have different opinions, but they are worthy of your courtesy. Agenda item number 4. All right, this is the adoption hearing regarding proposed regulation R001-26P. Okay, R001-26P. Existing law authorizes the Secretary of State to adopt and promulgate regulations and take other such actions as are necessary for the implementation and effective administration of the provisions of the Nevada revised statutes relating to campaign finance. And this is also, again, talking about the provisions of NRS 294A. Each former public officer, including a legislator who resigns from his or her legislative office, who has contributions that are not spent or committed for expenditure remaining from a previous election, is required to dispose of those contributions in a certain manner, not later than 15 days after the 4-year period immediately following leaving office. This regulation requires a former legislator who resigns from his or her legislative office to notify the Secretary of State of the resignation not later than 5 business days after the resignation is effective. This notification is in addition to any other notification required by law, such as the requirement that the resignation be delivered to the governor. Again, a little bit of additional context. So when a legislator, again, an assembly member or state senator resigns, the law requires them, and this is in NRS 218A.250, to notify the governor. That is the requirement. This is simply after That resignation has been submitted to provide notice to the Secretary of State so that we are aware and so that we can notify the filing office as well. Again, there were a few legislators who resigned in the last 12 to 18 months. And again, the key is to make sure that the appropriate people are aware and informed beyond the statutory requirements of the governor, so that we can make sure that we're providing ample time and information to commissioners and others that are asking about how to address those vacancies when needed. Okay. At this time, I will open up public comment on proposed regulation R001-26. We'll start here in Carson. Seeing no one, we'll go to Las Vegas. Seeing no one. Broadcasting, would you be able to check the phones, please?
Thank you, Chair. If you would like to provide public comment on R001-26P, please press star 9 now to take your place in the queue. Chair, you have no one wishing to provide public comment at this time.
Excellent. Thank you, broadcasting. Hearing no further public comment, regulation LCB file number R001-26P is adopted and will move forward to the Legislative Commission. Okay, agenda item number 7. This is the adoption hearing regarding proposed regulation R002-26P. Existing law requires a candidate to open and maintain a separate account in a financial institution located in the United States for the deposit of campaign contributions once the candidate receives minimum contributions of $100. Existing law sets forth campaign finance reporting requirements for candidates to report campaign contributions and campaign account balances to the Secretary of State. Existing law also requires such reports to be completed on a form designed and made available by the Secretary of State. This regulation requires a candidate who is required to report contributions received and account balances in reporting periods to include in each report the amount of interest accrued during the reporting period from the money in the campaign account maintained by the candidate. Again, this one additional context is just simply to capture and provide clarity. A number of candidates have reached out to the office over the last few election cycles asking if or how to report bank interest. So this regulation simply codifies that, yes, if you have bank interest, it keeps it easier and clean from a transparency standpoint to report that on the normal reports that otherwise require disclosure of campaign contributions. At this time, we will go to public comment on proposed regulation R002-26P, starting first here in Carson City. Seeing no one, we'll go to Las Vegas. Seeing no one, broadcasting, could you check the phones, please?
If you would like to provide public comment or R002-26P, please press star 9 now to take your place in the queue. Chair, you have no one wishing to provide public comment at this time.
Okay, thank you, broadcasting. Hearing no further public comment, regulation LCB file number R002-26P is adopted and will move forward to the Legislative Commission. We will now open the adoption hearing regarding proposed regulation R003-26P. Okay. Existing law requires the county clerk to notify a registrant if any elector or other reliable person files an affidavit with the county clerk stating that the registrant, 1, is not a citizen of the United States, or 2, has moved and established residence outside of the boundaries of the county where he or she is registered to vote with the intention to remain there indefinitely and abandon his or her residence in the county. Existing regulations establish requirements for the form and content of certain written challenges for the right to vote of a person. This regulation establishes such requirements for an affidavit filed with the county clerk by an elector or other reliable person to challenge the registration of a voter on the grounds of citizenship or residency by requiring the affidavit to be on a form prescribed by the Secretary of State and contain certain information. This regulation additionally requires the county clerk, upon receiving the affidavit, to conduct an assessment to determine whether the person who filed the affidavit is an elector or other reliable person. Finally, this regulation requires the county clerk to maintain certain records relating to this assessment for at least 2 years and authorizes the county clerk to share such a record with the Office of the Secretary of State or another county clerk or a city clerk upon request. There has been, again, there's one additional change that we are going to be adopting into the record that I want to make sure I describe very clearly. This is, again, the first part ties in to the definition of personal knowledge. Specifically, I am looking at, this is down in section 1 on page 2. You'll see there's the term personal knowledge in subsection 1F. It talks about a statement that is that the affidavit is based on personal knowledge. If you scroll a little bit further down to the last page, and this is the bottom of page 3, it has a definition. This is in now, this is still section 1, but now in subsection 5. It says, as used in this section, quote, personal knowledge means firsthand knowledge through experience or observation of the facts which the affidavit filed pursuant to NRS 293-535 is based. The proposed change that we're going to be adopting simply clarifies, as used in this section, personal knowledge of the facts upon which the affidavit filed pursuant to NRS 293-535 is based, means firsthand knowledge through experience or observation. Then we'll include some subcategories to further clarify, and this is going back just directly to the statute, but we're going to include it for additional clarity in this regulation. That A, that the registrant is not a citizen of the U.S., or B, that a registrant either has permanently moved outside the boundaries of the Nevada county where the registrant is registered, 2, has permanently established residence outside of the Nevada county where that individual is registered to vote, and 3, has permanently abandoned his or her residence in the Nevada county where registered to vote and intends on remaining outside of the Nevada county where that registrant is registered with no intention of returning to that county. What we're also going to continue to clarify, as it stated, the term does not include speculation or knowledge obtained from a third party, including without limitation, information obtained from the review of data in a database or other compilation of information. And if the person filing the affidavit is determined to lack personal knowledge under this definition, that person shall not be deemed or otherwise considered to be a, quote, reliable person for purposes of the provisions of this chapter. Then again, that subsection will be the same as used in the section, NRS 293.303. Personal knowledge means knowledge through firsthand experience or firsthand observation. Again, also term does not include speculation, hearsay, knowledge obtained from a third party, including without limitation, information obtained from the review of data in a database or other compilation of information. Again, this is simply adding additional clarity, tying it back directly to the statutes, so it's very clear the origin of the requirements. In that way, if there's additional questions, again, it points to the statutes to make it easier to understand. Okay, at this time, we will open public comment on proposed regulation. Oh, wait a minute. I'm terribly sorry. I just read that was R103. I jumped ahead in the agenda. So one quick moment, real fast. Yeah. So I apologize again. I got a little ahead of myself. I'll blame the weather. I had inadvertently jumped to agenda item 13 and talked about that was R103. But we're going to stick with the agenda. I'm going to rewind a bit. Please disregard all of that, and we will start again. This is back on the adoption hearing for proposed regulation R003, not R103. Please forgive me. Okay, so proposed regulation. This is agenda item 10 now, adoption hearing regarding proposed amendment and this is for LCB file number R003-26. Okay, so existing law requires Secretary of State to adopt regulations for the conduct of elections. Existing regulations provide for certain audits to be conducted after an election, including a post-election certification audit of voter verifiable paper audit trail, printers, and risk limiting audits. If a county used electronic tabulators in an election, this regulation requires a county clerk to conduct a post-election certification audit of electronic tabulators used in the election. This regulation sets forth the process for the county clerk to conduct such an audit and requires, if a discrepancy of 4 or more votes is discovered during the audit, the county clerk to immediately notify the Secretary of State and investigate the cause of discrepancy. Additionally, this regulation requires the county clerk to transmit the results of a post-election certification audit to the Secretary of State within 9 days after the date of the election, but before the canvass, and to include in the results an explanation of any discrepancy discovered by the clerk during the audit, and if determined, an explanation of what caused the discrepancy to occur. Finally, this regulation prohibits any member of the public who observes such an audit from interfering with the conduct of the audit. Again, this is proposed regulation R003-26. Again, there are a quick minor edit to this one as well that I want to read into the record. Following some discussion with some of our county election officials, it was identified that there were 2 parts that we're going to amend. I'm looking specifically in section 1, down in subsection 3. Instead of limiting it to not less than 1%, we are going to remove the text that starts about by randomly selecting a batch of votes equal to not less than 1%. And then there were 2 subsections below that that we're removing as well. And that's in section 3 and in section 4. And instead clarifying that the audit must compare votes cast on the randomly selected tabulators during the period of in-person voting, during early voting, and on election day. The effect of this change is that it's going to increase the amount of flexibility. So again, a number of our counties are looking to do larger audits. Again, which is something I think we would all appreciate. That larger sample size, again, because it's different across the 17 counties, by simplifying it in this regulation, in clarifying that we are going to be doing this audit of in-person voting during the early voting period and on election day. Again, it opens up the aperture for more flexibility at the county level. The other, again, very important change that I want to highlight is also in section 1 of the proposed regulation, but if you go down to subsection 5, it previously said if a discrepancy of 4 or more votes is discovered during a post-election certification audit, we are amending that to if any discrepancy is discovered during a post-election certification audit. So that again raises the bar considerably and will make sure that the Secretary of State is notified if any discrepancy is discovered during a post-election audit. So those are the 2 proposed changes in this is proposed regulation R003-26. Okay, so now I will go to public comment on proposed regulation R003-26. This is agenda item 11. We'll start in Carson City. Seeing no one, we'll go to Las Vegas. Seeing no one. Broadcasting, can you check the phones, please?
Thank you, Chair. If you would like to provide public comment for R003-26P, please press *9 now to take your place in the queue. Chair, you have no callers wishing to provide public comment at this time.
Thank you, Broadcasting. In that case, we will close public comment on proposed regulation R003-26P. And hearing no further comments, regulation LCB file number R003-26P is adopted as changes reflected on the record and will move forward to the Legislative Commission. Okay, agenda item 13, for real this time. Adoption hearing regarding proposed regulation R103-25P. Okay. Existing law requires the county clerk to notify a registrant if any elector or other reliable person files an affidavit with the county clerk stating that the registrant, 1, is not a citizen of the United States, or 2, has moved and established residence outside the boundaries of the county where he or she is registered to vote with the intention to remain there indefinitely and abandon his or her residence in the county. Existing regulations establish requirements for the form and content of certain written challenges for the right to vote of a person. This regulation establishes such requirements for an affidavit filed with the county clerk by an elector or other reliable person to challenge the registration of a voter on the grounds of citizenship or residency by requiring the affidavit to be on a form prescribed by the Secretary of State and contains certain information. This regulation additionally requires the county clerk, upon receipt of the affidavit, to conduct an assessment to determine whether the person who filed the affidavit is an elector or other reliable person. Finally, this regulation requires the county clerk to maintain certain records relating to this assessment for at least 2 years and authorizes the county clerk to share such a record with the Office of the Secretary of State or another county clerk or city clerk upon request. Okay, so now again, the changes specific to R103-25. We are going to amend again the definition of personal knowledge. Again, personal knowledge is in section 1. Down under 1F is a reference to the use of personal knowledge and the importance that the affidavit be based on personal knowledge. The definition, if you scroll down to the bottom of the page, is in subsection 5, which it says, as used in this section, personal knowledge means firsthand knowledge through experience or observation of the facts upon which the affidavit filed pursuant to NRS 293-535 is based. Our proposed amendment that we are going to adopt is again clarifying simply that personal knowledge ties back to the statute, to NRS 293.535, and clarifies that this is firsthand knowledge through experience or observation that the registrant is not a citizen of the U.S. or that a registrant has permanently moved outside the boundaries of the Nevada county where the registrant is registered, or has permanently established residence outside of the Nevada county where that individual is registered to vote, and has permanently abandoned his or her residence in the Nevada county where registered to vote and intends on remaining outside of the Nevada county where the registrant is registered with no intention of returning to that county. Again, we're still clarifying that the term does not include speculation or knowledge obtained from a third party, including without limitation, information obtained from the review of data in a database or other compilation of information. And clarifying that if the person filing the affidavit is determined to lack personal knowledge under this definition, that person shall not be deemed or otherwise considered to be a, quote, reliable person, end quote, for purposes of the provisions of this chapter. Again, we're also looking to tie it to, again, NRS 293.303 also has a reference to personal knowledge, which clarifies that personal knowledge, again, through firsthand experience or firsthand observation, means knowledge through firsthand experience or firsthand observation. The term does not include speculation, hearsay, or knowledge obtained via a third party, including without limitation, information obtained from the review of data in a database or other compilation of information. Okay, at this time now, we are going to open up public comment on proposed regulation. This is R103-25P. We'll start here in Carson City. Seeing no one, we'll go to Las Vegas. Seeing no one broadcasting, can you check the phones, please?
Thank you, Chair. If you would like to provide public comment on R103-25P, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to provide public comment at this time.
Thank you, broadcasting. In that case, we will close the public comment on proposed regulation R103-25P. And the proposed adopted regulation with the LCB file number R103-25P is adopted with the changes as read into the record and will move forward to the Legislative Commission. At this time, this will go to general public comment. Again, this is agenda item 16 now. Public comment on matters other than the previously listed LCB file numbers. Comments limited to 2 minutes per person. If anyone is interested in providing public comment on a matter not on the agenda, please identify yourself and come to the table. Not seeing anyone here in Carson City. No one in Las Vegas. Broadcasting, can you check the phones, please?
Thank you, Chair. If you would like to provide public comment, please press star 9 now to take your place in the queue.
Good morning. My name is Ellen Gifford, ELLEN, GI in Frank, ORD as in David. On December 4th, 2023, a Nevada voter sent a public records request to the Nevada Secretary of State. On December 19th, 2023, the Secretary of State responded saying they expected to provide the requested records by February 23rd, 2024. During the year 2024, the requester received a monthly memorandum from the Secretary of State requesting an extension to the next month. Then in November, the memorandum requested an extension to January 2025. During the year of 2025, the requester received sporadic memorandums requesting extensions. The last one was received December 12, 2025, requesting an extension to March 20th of 2026. It's easy to think after all this time that someone is having a lark of some kind. However, the memorandums look authentic and the sender's address is correct, so they are definitely coming from the Secretary of State's office. One would think that a phone call to the requester to provide some insight as to why it's taking years to respond to their request is the very least this Nevadan deserves. We respectfully request that someone in the Secretary of State's office step up and address this issue. We've brought it to their attention on behalf of the requester countless times, and there has been no response. Thank you.
Chair, you have no more callers wishing to provide public comment at this time.
Thank you, Broadcasting. If there's no more public comment, then we'll close the general public comment at this time. As a reminder, though, this adoption hearing is not the end of the regulatory process. Following the completion today, again, the next step will be for these adopted regulations to go before the Legislative Commission. Again, that's next Thursday, February 26th at 1 p.m. Additional information can be found on the Nevada Legislature website, which is leg.state.nv.us. If you have any other questions or difficulty finding the agenda for that meeting, please don't hesitate to reach out to the Elections Division at 775-684-5705 or via email at nvelect@sos.nv.gov. And then lastly, again, appreciate everyone who, again, worked to make these adoption hearings and this regulatory process for the Elections Division successful. Not only our colleagues at the Office of the Attorney General, but the clerks across our state, counties, and cities who provided feedback, and the number of SOS staff who contributed. Very much appreciate their hard work and efforts and eagerness and willing to help overcome even the weather here in Carson to make sure that this process happened the way it needed to. So thanks also to everybody at LCB. Very much appreciate your assistance and to our interpreters as well. So that being said, this concludes our adoption hearing and we are adjourned. Thank you.